Good afternoon, everybody, and welcome to the Appellate Division First Department. We have about 6 hours of argument time scheduled here, and I know you don't want to stay here that late because there is a Mets game and other interesting things going on, so nobody wants to be here that late tonight. Any event, I would ask you to please just ask for the time that you really need. Remember, we have had your briefs and records. We are familiar with the cases, and we just want you to hone in on the important issues. We'll give you time, the light, when it's a white light, that means you have 2 more minutes. When there's a red light, that means you should wrap up your thoughts. If we still have questions, we will keep asking questions. The red light's for you, not for us. So I'm going to call the calendar. Both parties, please get up and appellant and then respond and tell me how much time you want, and we'll see what we can do with that. Okay, first case, People versus Ledesma. Are you the appellant? No appellant here? Do you still want to argue or do you want to submit? Okay, thank you. Shanghai Pearls and Gems versus Paul. Do you want rebuttal? Okay, and responding? You don't have to tell me your names right now, just... Okay, so 6 and 2 for you, and 8. Thank you. M. Children, submitted. Daily New York City versus Shay. Respondent? 5 and 2 and 5. Thank you. Newson versus Vivaldi Real Estate. Well, who's the appellant? Appellant not here? Okay, well, do you still want to argue? You still do? Okay, so we'll give you 3 minutes if you need more than that. Okay, so there'll be nobody for the appellant and 3 minutes for the respondent. Okay, thank you. People versus Jose Urena. Okay, and respondent? Okay, 5, 2, and 5. Sorry about this one. Riseo versus City of New York. Respondent? Okay, you have a cross appeal, right? Okay, so I'm going to give you 5 and 2, and I'll give you 5 and 2, okay? Presley versus 535 Greenwich. Okay, is there a respondent? So counsel, do you still want to argue? You will submit? Okay, so Presley is submitted. Thank you. Howard versus New York City Police Department.
15 minutes argument, 15 minutes
Rebuttal.
Yes.
Respondent?
15 and 15.
Okay, I'm going to give you 5 and 2, sir, and I'll give you 5. Thank you. People versus Michaud. Nobody? Okay, submitted. GIT versus Quinn Emanuel.
Appellant 6 and 2.
Respondent? Okay, 6, 2, and 6. Thank you. Cartagena versus Hansford. Respondent?
Respondent 5, please.
Got it. 5, 2, and 5. Zabal versus City of New York. Well, appellant first.
Appellant Riseo 5 and 2. 7 and 8.
You don't have a cross appeal, do you?
No.
Okay, so I'm going to give you 5 and 2. I'll give the other appellant 5 and 2, and I'll give you 5. Thank you. People versus Diallo. Submitted. Amkajar Realty versus Butter Management is submitted, and Bacon versus Nygaard is submitted. First case for argument is Shanghai Pearls. You may step to the podium whenever you're ready.
May it please the court, it is an ancient and fundamental principle that rights are transferred via assignment. They are not created via assignment. An assignee always stands in precisely the shoes of its assigner and receives no greater interest than its assigner had. We cited international ribbons from the Court of Appeals for this basic principle that's taught in first-year law school classes. And the result of this principle, as this very court has held, is that assigned interests are subject to the same infirmities, the same equities, and the same defenses that they had in the hands of the assigner. We cited Battison liquidity for that. So that takes us to the second set of guiding legal principles that are relevant on this appeal. The claims at issue here, the claims that were filed against the defendants, Essex Global Trading and Alex Paul, are barred by the doctrines of settlement and release and the doctrine of res judicata. That is because plaintiff respondent ultimate received the claims that it filed in this action against Essex from a bankruptcy trustee in 2022 via an assignment. But the claims ultimate received had already been filed by the trustee in the bankruptcy.
So, counsel, can I ask you when the transfer of the 2/3 of the interest, right? Because 1/3 is owned by the plaintiff straight out.
Right.
When that 2/3 transfer occurred, was that before or after the bankruptcy court settlement?
Your Honor, that occurred, the interest, the claim was transferred, and that interest happened after the Essex settlement had already been interposed.
So the settlement, so anything, all that, at that point, the transfer could do was whatever the transferor had, and at that point, the 2/3 owners had released their claims, correct?
That is precisely correct, Your Honor. But in addition to that, there's a res judicata argument, and we cited Grammaton for this principle, that when—
Well, at least with respect to the 1/3 claim, right?
Well, with respect to the 1/3 interest, that has been claimed by ultimate, by the trustee, and by every party in this action as not being in a state interest. It was something that ultimate is claimed as that.
Right, but in terms of, you're saying that there's a statute of limitations issue with?
With respect to the 1/3
Right.
interest, right.
Okay.
The res judicata, settlement and release, all those doctrines apply to all of the interests that ultimate
So
received.
at the time that the settlement was reached, were all parties, including the plaintiff here, ultimate, were they all in the adversary proceeding?
Yes, they had been
So
named in.
ultimate could have made the claims that it's making now in that adversary proceeding?
It was, yes, it was named, it appeared,
It appeared, I
and
remember.
then when the Essex settlement that released Essex from all of these claims was filed for approval with the bankruptcy court, ultimate filed an objection.
Right.
Then ultimate withdrew that objection with
Then
prejudice.
didn't Ultimate enter into its own settlement agreement with Essex?
Not with Essex, Your Honor, no.
With D&M?
Yeah,
D&M.
correct. And then, and that settlement in which it received the interest that it's bringing now was specifically made and expressly made subject and conditioned to the court's ordering and approval of the Essex settlement. This was a very—
So you're saying that that settlement, the Essex settlement, was incorporated into and conditioned on, the plaintiff's settlement was
And
incorporated in?
yes, and there's proof—
Let me just ask you straight, so is it your position that this plaintiff could have asserted the claims that it's asserting now in the adversary proceeding against the consignee, I guess, of the interest, Essex?
It is, Your Honor, but that is not what our argument turns on. Our argument turns on the fact that the claims that they have brought were received from the trustee, and what the trust— so ultimate got a few things from its settlement with the trustee. One, it was in possession of $300,000 worth of estate inventory. It got to keep that $300,000. Two, it received 2 items that Essex had a lien against. Essex is the biggest secured creditor in this bankruptcy. It has biggest creditor in the bankruptcy, and it's a secured creditor, first in line. It put 2 of the 6 items at issue into the bankruptcy estate's possession, and as part of the settlement that Ultimate got, it got to keep 2 of the items that Essex had a lien against.
Yeah, but what has that got to do with whether or not res judicata applies here?
It has to do with whether Ultimate's settlement is contingent upon the approval of Essex's, because they couldn't have gotten the items that they got in their settlement with
Yeah,
the
but how,
trustees.
so what if, so I guess my point is, so what if it was contingent? Are you saying that those terms were incorporated into the plaintiff's settlement?
What I am saying is that the releases were incorporated into the
Well,
plaintiff's
the
settlement.
releases are incorporated because of the assigns provision, not because of the fact that their settlement was contingent. That's what I'm saying. I don't understand why you think that that's relevant.
Well, frankly, Your Honor, I do agree with you.
Well, I'm not saying that they didn't get anything, but why does that matter as to res judicata, right? Their assignment is, the reason why you're saying they don't have any claims is because they can only get what there was, and there was a release before they got it, right?
For the assignment argument, that's exactly right, Your Honor. Res judicata is a separate argument because the claims were in fact filed and then dismissed with prejudice.
Fair enough, okay.
And I do,
Well, your time is up, so you have a few minutes on rebuttal, okay?
thank you, Your Honors.
Thank you.
Okay. May it please the court, on behalf of respondent, it's our position that the trial court,
Now, what is your name, just for the record?
Of course.
Who are you?
David Kaplan, Guzav LLC, for respondent Shanghai Pearls and Gems.
Thank you.
The trial court in this case was faced with a motion to dismiss the complaint on the pleadings. It was not converted to summary judgment. And the trial court's decision denying that motion properly recognized that this was an early stage of the proceeding, and that unless contradicted by documentary evidence, irrefutable documentary evidence, the allegations in the complaint were entitled to be taken as true.
Well, I mean,
And that's
statute of limitations is also is often something that we do decide on a motion to dismiss. What did we not have available to us to help us figure that out?
Well, I think in that case, the trial court properly found that the automatic stay in bankruptcy acted as a toll of the statute of limitations.
Well, what support do you have for that proposition that the bankruptcy proceeding actually created a toll as far as our case is concerned?
Well, the terms of the automatic stay statute states that actions relating to the custody of property of the estate are stayed and cannot be brought outside of bankruptcy. Now, had we proceeded as appellant suggested and brought a fraudulent conveyance or a conversion action during the bankruptcy proceeding, there would be no way to try those claims without deciding whether my client or his client should be the proper owner of the 2 gems that are at issue in this case. And meanwhile, there is a third claimant.
What about the adversary proceedings that were going on in bankruptcy court at the same time? That none of them could deal with these issues at that time?
Your Honor, in the adversary proceeding that we were party to, we were named as a nominal defendant. And in that case, it was not the proper forum or venue in which to, bring claims that are primarily based upon state law. And there was no, as we understood it, because of the toll, there was no.
Well, let's go back to the toll, right? These parties are not, the parties you're suing now are not parties in the bankruptcy proceeding. They're not the bankruptcy estate, correct?
They were a creditor in the.
Right, doesn't matter, but the creditor is not what the 362 stay has to do with. It has to do with the bankrupt party and the bankrupt estate. You're not seeking any money, you're not seeking any property of the bankruptcy estate, are you?
Our claims sound in damages, but in order to.
What property of the bankruptcy estate are you seeking?
At the time that the adversary proceedings were going on, the physical possession and title to the 2 gems at
I'm talking
issue
about,
were-
you're asking to seek a toll in this action based on the bankruptcy stay. So what you have to show is that the party was bankrupt, was part of the bankruptcy, which this party was not the bankrupt party or the bankrupt party's estate, and you have to show that you are seeking something from the estate. So I'm asking you, what property of the estate are you seeking that would this bankruptcy stay would apply to?
We were seeking a ruling that we were entitled to damages
A
based
ruling,
on-
there's property, there's real property. The stay isn't just everything that ever happens around the bankruptcy, as we both could agree.
If I may, were you seeking recovery of the pink diamond?
In this action, no, we're seeking damages.
Right.
Had there been
This
an
goes back to what my colleague is asking you, because it's not the pink diamond, it's money damages. So how does that relate to the property of the estate?
It relates to the property of the estate because there's no way to try the issue of who's entitled to damages based on conversion of the property or fraudulent conveyance of the property without establishing who's entitled to the property in the first place. And while the bankruptcy proceeding is going on, the bankruptcy estate is saying, no, 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 that belongs to us. We're saying,
And so why could you not have commenced an action, an adversary proceeding in the bankruptcy action?
with respect to the 33% interest that my client owned throughout the proceeding, throughout the case, the ones that were, just so I understand the question, you're not asking about the ones.
I'm not
received by
asking because
assignment.
you're already in that one. You're in the bankruptcy proceeding. You appeared. You objected to the settlement of the adversary proceeding. You're in the bankruptcy. We're only talking about the 1/3, which the statute would have run on. So why could you not have brought a proceeding, an adversary proceeding?
Sitting here today, I don't know of a reason.
Right. So that's why I don't see how the bankruptcy stay could extend your toll.
Well, the trial court also did find that with respect to the other property, the other interests in the gems, that the claim never accrued until the time of assignment. That brings up the arguments concerning res judicata and the
Sir,
scope of
why
the release.
then withdraw your objections in the bankruptcy proceeding with prejudice? If you felt there were claims that couldn't be addressed in that form, or you wanted to leave open to litigate another day, why withdraw them with prejudice?
I believe that was a requirement to close the settlement. I don't know in what sense I don't know why the trustee would have accepted, a settlement without prejudice. All right, so let me just touch briefly, if I may, on release and res judicata. With respect to res judicata, it applies where parties are in privity, and that's a factual determination. And it's our allegation here that based on the allegations of fraud, fraudulent conveyance, fraudulent collusion between the D&M entity and Essex, that they should not be viewed, even when supplanted by the trustee, they should not be viewed as having an equal incentive to litigate the claim as we would have done. So that deals with res judicata. And with respect to the release, on page 10 of our brief, another ancient maxim of the law is that you can't release a claim a claim that you don't own. And there was never any, as we show that the trustee may have controlled the timing of bringing the fraudulent conveyance claims, but they did not own them. And since they didn't own them, they could not release them.
Thank you. Counsel, you have 2 minutes for rebuttal.
I would just like to touch on this last point. Ultimate hasn't found a single case in which a fraudulent conveyance claim was brought by a trustee, resolved with prejudice by a bankruptcy court order, and then after the fact, challenged by a creditor in a completely different forum. And we know it's not from lack of trying, because in their brief, they cited 2 cases from the Puerto Rico District Court. They cited 2 cases from New Mexico. They did an exhaustive nationwide search in researching, and they can't find a single case in which that happened. We found the case in which that happened, though, and that's the Cho case in front of District Court Judge Catherine Fea. And In the Cho case, the court looked high and low for precedent in which somebody could watch as a claim was adjudicated and dismissed with prejudice in the bankruptcy court and then collaterally attack it later on. And the court could not find one because they simply don't exist.
And when they objected to when the plaintiff objected to the settlement, what were the grounds of the objection? That they owned the property, or that this was a fraudulent conveyance?
No.
And could they have asserted that claim in terms at that time in the bankruptcy?
They absolutely could have asserted it then. They absolutely did not make a standing objection at the time. No one did. In fact, because the trustee was vigorously litigating this, which is why a $6.5 million secure claim went off the books of the bankruptcy estate, and $350,000 went into the bankruptcy estate, and the estate got to keep two items that Essex had a lien against, and those items went to Ultimate. So they're not just looking for two bites at the apple. They are trying to bite the hand that fed it ultimately, because they benefited from these settlements between the estate and Essex. Thank you very much.
Okay, thank you. Thank you both. The next case for argument is Doy, New York City versus Shay. Okay?
May I proceed?
Yes, you may.
Good afternoon, Your Honors. My name is Jonathan Edelstein from Edelstein and Grossman. I represent the plaintiff appellant Doy NYC. Starting with the timeliness ground that the respondent raised as an alternative ground for affirmance. This lease had an extended cure period, and the principal of Doy attested to the various difficulties that he was working through with the engineer and the architect, and the various difficulties and backups that had occurred with the property. And he stated that he was, quote, currently working with his architect, that this was an ongoing process that had been going on both before and during the cure period. Those are circumstances in which this court has repeatedly held that a de minimis one-day delay can be excused. And in fact, in the Elite Wire and Spirit case, which is cited in our, I believe in both briefs, this court stated that even if the defendant is disputing the diligence or the effectiveness of the tenant's efforts, that the court still has the discretion to entertain an untimely Yellowstone application. So therefore, the IAS court was correct in excusing the one-day delay.
But let me go to one of the things I think is a crucial aspect here. There were a few different defaults that were alleged in their notice of default, right?
Yes.
Let's deal with the insurance issue. How do we get past the insurance issue? There was supposed to be $2 million worth of coverage. Looking at the deck sheet, it does not look to me like there was $2 million worth of coverage. How is that a curable default, no matter how many days you had to do it? And what did you do to indicate you were making an effort to attempt, if you could, to cure that default?
Well, it's not a default because the deck sheet shows there was $2 million aggregate. The lease doesn't say $2 million per occurrence.
What does $2 million general aggregate mean?
That's the policy limit for the policy period. It's an aggregate limit of up to $2 million for all occurrences within the policy period. And this is the exact issue that was addressed by this court in the Booston case, in which there was a
Wait,
lease
may I
that-
interrupt you just a
Yes.
second? This policy says, with limits of $2 million for bodily injury or death and $2 million for property. Clearly, your policy doesn't have that, right? Are you saying that your policy has $2 million for occurrence for bodily injury and $2 million for property damage?
No, it doesn't have $2 million
So
for occurrence.
how could this policy have complied with this lease?
Because the lease didn't say per occurrence. The lease did not say that it had to be $2 million per occurrence. And in the Booston case, it says that where the lease does not specify that, there is at minimum an ambiguity, and that $2 million of aggregate coverage, which this deck sheet has, is enough to qualify.
So are you, the policy does say $2 million for bodily injury or death and $2 million for property damage. So you saying to me that this policy has at least $2 million for property damage?
Yes, the aggregate $2 million limit covers both property damage and bodily injury. It's a $2 million aggregate limit for all coverages. It's not per occurrence, but it is aggregate. And in the Booston case, this court held that where the lease does not specify per occurrence, that it's enough to have an aggregate policy limit. And turning to the respondent's alternative argument that the managing agent was not named as an additional insured, not only had the landlord not complained about this for 2 years, and they hadn't complained about any of the insurance coverage for 2 years.
Yeah, but that's irrelevant. You know why they didn't they didn't complain? Because nobody put in, no one slipped and fell at the property. But if someone slips and falls, or 4 people slip and fall at the property, and the coverage is inadequate, there's nothing you can do to fix that now, right?
Well, the case law says that where there's no prejudice to the landlord.
Let me go
which
back
there
a
was-
second. We don't know if there's prejudice. The time period hasn't ended yet. I mean, who knows? Claims could still be coming up. But let me ask you, what did you put in? What, if you're arguing an extended period, what did you put in to show that you could go back and fix if at the end of the day, it's $2 million per occurrence and $4 million total? What are you saying that you, what are you putting in that would excuse your failure to seek a Yellowstone injunction within the period, the 15-day period?
Well, our position was that the insurance was never a default.
Okay,
And that
so
on the sign-offs,
so
we
if
had been...
that's your position, then you don't get the extended period. You can't get an extended period unless you're saying, I'm trying to work it out, right?
Well, they said they were trying to work out the sign-offs, which
I'm
were
not
the
talking-
default.
There are
that-
3 different, you have to, if you want the extended period, you have to show, with respect to each of the defaults, either that to get out of your 15-day cure period, to get the Yellowstone, you have to show you're doing something, right?
If one of the defaults was never a default in the first place, there's no obligation to do anything about that.
Except you have to move for the relief within the 15-day period then. You don't get the extended cure period if your position is that it's not a default, right?
Well, if there are 3 defaults being raised, and there is an extended cure period where they're being raised, where there is at the very least an allegation that one of them is not a default and the other 2 are in the process of being cured, there's no case law that I know of, and certainly none that has been cited by my opponent, that says that the salami gets sliced that way and you can only get a Yellowstone as to some of the claims but not others. That if you're entitled to the extended cure period on anything, you're entitled to it on everything.
Do you have a case that says that?
Certainly no case that says that,
I'm
that
asking,
the
right.
opposite of that.
Right. I mean, there are cases that say that if you find that the cure period is gone, then there's nothing more to do, even if there are other defaults. But I'm curious as to whether you found a case where the court said, even though one of the defaults was not curable, that you could have an extended cure period.
I mean, since this issue is being raised now, it's not something that I've researched. It was not raised by my opponent.
Well, I mean, your opponent did raise. All right, you're over and I'm over.
Okay, you'll have a few minutes on rebuttal. Let's hear from the other side. Thank you.
Good afternoon, Your Honors. Michael Charlo of Maydell and Charlo for the respondent. If it pleases the court, just very briefly on the...
Can you answer, can you try to explain that issue about the insurance? I mean, is he right or is he wrong?
Yes,
I
I'll go-
have the deck page on it. What does that general aggregate mean?
I'll go right to the insurance. So the lease provides comprehensive general liability with limits of at least $2 million for bodily injury or death and $2 million for property damage, which equals $4 million. Whether you argue if it's per occurrence, clearly.
Well, it doesn't say that, so we don't know if it's a per.
Right, well, I'm going to argue both. So if the court would find that the provision's not vague and it's per occurrence, clearly, as Your Honor said, this policy does not cover per occurrence $4 million. It covers each occurrence $1 million. It recovers property damage to the premises of $100,000. An aggregate is what the policy would cover during the period term. So if there was a fire and someone was injured, the policy requires that for bodily injury or death, it would pay out $2 million. And for property damage, it would pay out $2 million. That's what's required under the lease.
And there is an excess provision.
Yes, right. So this policy for occurrence, if there's a fire, it's only going to pay out $1 million under the general liability policy. And then you have the umbrella, which would pay out another $1 million. But as Your Honor pointed out, and counsel continually misstates, it's not $2 million for property damage and bodily injury. It's $2 million for property damage and $2 million for bodily injury. So let's say counsel's correct in the Booston holding, and this is considered vague. So if it's considered vague, counsel has argued this should be determined to be aggregate limits. Aggregate is the amount that'll pay out. So if there are 10 instances during the policy period, the most this policy would pay out would be $3 million. $2 million under the commercial general liability and an additional $1 million under the umbrella policy. So even if you were to hold these amounts in the aggregate, it still requires $2 million in the aggregate for bodily injury or death, and an additional $2 million in the aggregate for property damage. That's $4 million.
So could counsel have done anything to retroactively cure it retroactively or for cure it going forward?
No, the cases we cited in our brief, an insurance defect is not cured retroactively. As Her Honor Scarpula said, we don't know if somebody fell. Somebody could have fell and nobody knows about it. You can't go back and cure this. This policy from July 6, 2023 to July 6, 2024 only has an occurrence of $1 million and a general aggregate, if you total both the umbrella and the commercial general liability policy, of $3 million. So if somebody got hurt and there was a fire and there was $4 million worth of damages, if they had it in the aggregate like the policy requires, we would be covered. If it's only $3 million, they're only going to pay out $3 million, so we're out $1 million.
You want to deal with any of the other issues?
The department, the DOB sign-offs, I'll get into really quickly. The record is clear. No steps were taken prior to the filing of the order to show cause. The order to show cause was filed September 28th. The cure period expired September 27th. The record shows that the issue with not getting the DOB sign-offs was the tenant did not pay their architect for 11 months. There was nothing there's not one thing in the record that points to anything that was done prior to the expiration of the cure period. They simply said it's being worked on, and the IAS court said the record is devoid of any evidence that anything was done before the cure period. In order for the limited exception to expire, you need to have a lease provision that says you can have additional time to cure, which they do, but you also have to show good faith attempts. That's what Elite Wine shows. There has to be a good faith attempt made prior to the cure period to take steps to do it. The architect wasn't paid to October 24th, over almost a month later. Nothing was done prior to the cure period. Therefore, the court correctly held that the tenant was not entitled to a Yellowstone injunction. And for the insurance, no matter how you look at it, per occurrence, aggregate, it needed to be $4 million. It's not $4 million. Thank you, Your Honor.
Thank you.
Good?
No, that's fine.
Judge, the lease says $2 million. It doesn't say $4 million. It doesn't say that the $2 million coverage for bodily injury and the $2 million for property damage have to be separate, on one on top of each other.
Well, why wouldn't it just say $2 million for property and? Why would it say, well, I mean, it's pretty straightforward. $2 million for property, $2 million for personal injury. It doesn't say $2 million for property damage and personal injury, right?
Well, but it talks about one policy of general public liability insurance.
At least $2 million for bodily injury or death and $2 million for property damage.
Yes.
That says $2 million for each.
And the aggregate is 2 million for either one or both.
But that's not,
And
aggregate
look,
would
if-
be 4 million, right?
If the policy, if the landlord wanted to say per occurrence, or if the landlord wanted to say these 2 million are, have to be separate and distinct, and there has to be a total of 4 million, that could have been written into the lease.
But isn't that what it says? 2 million for this and 2 million for that?
Well, it's 2 million that could be read as 2 million for a combination of this and that. That it has to be 2 million and that it has to cover both the this and the that.
May I ask
Which is what we have.
May I ask you one more question? Do you agree with counsel that you did not begin to clearing up the DOB issues until after the order to show cause was filed?
No, Your Honor.
What did you do prior? What did you put in? Let me say, what's in the record?
That Mr. Santos discussed about how this work had been, was being done. It was being delayed by sewage backups, rotten boards, all of these things that were leading to delays and cost overruns. He did have some issues paying his landlord, the architect, but he was working on it throughout this period. And there is no dispute that by the time the order appealed from was issued, all of the sign-offs had been obtained. There's no dispute about that. Thank you.
Okay, thank you. Thank you both.
Enjoy the game.
Next case is Newsom versus Vivaldi Real Estate. And counsel, you are the respondent, right? So we gave you 3 minutes, so you may deal with your 3 minutes as you choose, okay?
Erin Evers with Brooklyn Legal Services for Appellate Terry Newsom. Your Honors, I will make 3 points today as to why this court should uphold the lower court's decision. First, the City Council has passed 2 statutes mandating courts to interpret the city human rights law as broadly as possible to effectuate its uniquely broad and remedial purposes. Critically, the 2005 and 2016 Restoration Acts require courts to treat state and federal anti-discrimination laws as a floor beneath which the city human rights law cannot fall. Applying these Restoration Acts to the city human rights law requires imposing vicarious liability on housing owners when their agents discriminate, because the Supreme Court's unanimous decision in Meyer versus Hawley that there is vicarious liability for principals when their agents commit housing discrimination establishes the floor beneath which the city human rights law cannot fall. Notably, Meyer versus Hawley did not limit its holding to the Fair Housing Act, but broadly held that there is vicarious liability for housing owners when their agents commit discrimination. Were this court to overturn the lower court's ruling and hold that the city human rights law provides victims of housing discrimination with less protection than federal law, it would be expressly violating the Restoration Acts. And appellants cannot cite a single authority for their position that there is no vicarious liability for housing owners in housing discrimination cases.
But the city council created a very delicate, finely tuned scheme for the city human rights law and has been quick to act when it feels that the law has not been interpreted in the manner it wishes it had, particularly more broadly. Why wouldn't it have been a simple thing for the council just to include vicarious liability if that's what they wanted?
Well, I think that it's because it's axiomatic that legislatures make laws against the backdrop of the common law, and the common law principle that tort principles of agency and vicarious liability apply to housing discrimination cases has been in place for decades. So when the legislature created the source of income discrimination law in 2008, it was doing so against that backdrop. And I would also just point out that appellants would have you ignore centuries of jurisprudence defining the relationship between legislation and the common law in order to restrict the most protective anti-discrimination law in the country without a single authority. They go so far as to assert that city and state legislatures do not make laws against the backdrop of the common law, which is frankly absurd. There's simply no legal authority for it. the City Human Rights Commission, which is the agency tasked with interpreting and enforcing the city human rights law, unequivocally and expressly states that the city human rights law imposes vicarious liability upon owners for the actions of their agents, and thus that homeowners must ensure that such agents are not discriminating in showing their apartments. Appellants misconstrue a handful of cases holding that discrimination is not literally a tort. In each of those instances, I see that my time is up. Should I finish my point or wrap it up?
I think we have it. Does anyone have any further questions? I think we're pretty familiar with the case. So thank you very much for
Okay,
coming
thank you,
in
Your
and
Honors.
for your argument. Have a nice afternoon.
Thank you.
Next case, People versus Urena.
May it please the court.
Good afternoon.
My name is Stephen Preziosi. I represent the appellant, Mr. Jose Urena. Your Honor, there were three distinct problems with the prompt outcry witness. One, there are addressed in points 2, 3, and 4 of my brief. One was the fact that this particular prompt outcry witness was permitted to be called. 2, the manner in which she was questioned. And 3, the way the people used that evidence in their closing arguments. And I'm going to try and get through those 3 points here today. So point 2 of my brief was there was not a factual basis to permit this witness, Raydelis Urena, the mother of the complaining witness, to be called as a prompt outcry witness. There was a handwritten note from the complaining witness saying, "I never told my mother about this." Never told my mother. The people's position was that this complaining witness had made a prompt outcry to the mother in 2013, which their complaining witness negates, denies. There was no factual basis to permit Raydelis Urena to be called as a prompt outcry witness, but they did call her. They did call her at trial.
Counsel, may I ask you, was this claim preserved?
Yes. There was
was it
a prompt outcry hearing in which defense counsel objected on several grounds. The people actually put forward 4 prompt outcry witnesses.
And there was a whole hearing, and the judge
Correct.
allowed 2
April
and didn't
4th.
allow 2, correct?
April 4th, 2018 was the hearing, Your Honor.
Well, wasn't the defendant's claim in that hearing that the 2 statements were inconsistent?
Yeah, they contradicted one another. The complaining
Right.
witness had a handwritten note. This was the handwritten note that's oft quoted in my brief, in my
I thought you
friend
were
across the
saying on
aisle's brief.
appeal that it wasn't prompt.
Well, one of the witnesses was not prompt, was
That
decidedly
wasn't-
unprompt.
so that wasn't preserved, right?
Defense counsel did make an objection, saying that Mr. Alia's state testimony as a prompt outcry witness was not prompt. The alleged actions that are the subject of the indictment were concluded in August of 2014. The statement, the prompt outcry witness, Mr. Elia, the guidance counselor, was the outcry was 2016, almost 2 years later. That's really not part of my point in point 2.
really
My
focusing on
point
the
2
mother.
is with regards to Raydelis Urena. That
And-
there was
and
no
you're-
factual basis to call her as a prompt outcry witness. And in fact, when they did call her, she said, I don't remember any of this,
Right.
that my daughter came forward to me in 2013. Which
Counsel,
brings,
just to go back, the objection to the mother was that the statements were inconsistent, not that the statements were not prompt, not a prompt outcry.
correct. They were contradictory. Which brings me to,
So how is that preserved?
because defense counsel objected to it at the prompt outcry hearing. He made that objection.
No, on
brought that
what
up.
ground? Your argument here, the ground that you're arguing here is that it wasn't prompt, right? Or are you arguing
No,
the same
it was
thing,
it
that
was
just
completely
because it was
contradictory. There must be some
inconsistent?
factual basis to call someone as a prompt outcry witness, where the complaining witness contradicts, "I never told my mother." The people cannot say this is a prompt outcry witness that the complaining witness came forward to in 2013 when our complaining witness said she didn't. That's the problem.
So you're saying
That's
the
the basis of
problem
point 2
is
of my
the
brief.
inconsistency, not the time difference. That's your appellate
the prompt
argument?
is with regard to Mr. Elia,
Well,
the separate prompt outcry witness.
Wasn't there testimony perhaps inconsistent both ways? At one point, the complainant said she was too afraid to tell her mother, so she didn't say anything. Yet at another time, she stated that she told her mother in 2013 when she was 11. So there was some testimony.
Her written note to her guidance counselor at school was, "I never told my mother."
But there had
And then
been
her
other
testimony changed at
testimony.
trial. So, which brings me to point 3. Point 3 was the violation of CPL 60.35. Basically, there's a couple of twists and turns to the statute. It's subsection 3 of 60.35. Basically, you can't introduce a prior statement if it doesn't disprove their position. So the people couldn't introduce a prior statement when on the direct examination of Raedelis Urena because it was inconsistent with her trial testimony. So the objective of 60.35 subsection 3 is can't impeach your own witness, and you can't, most importantly, try and refresh the witness's recollection with the prior statement, and you can't introduce the facts of that prior statement. So we have two reports, the report from Detective Berenger and the report from the CPS worker, neither of which was ever introduced into evidence, and they are not part of this record on appeal, neither of them. They were
But can't
extensively
couldn't
discussed.
they have been used as they were attempted to be used to refresh the recollection even without there having been put into?
60.35 sub 3 forbids it. Says no, you may not. Judge, let me please read this. I know I said it's got a couple of twists and turns. Let me just read, read the statute. Here's 60.35 subsection 3. When a witness has made a prior signed or sworn statement contradictory to his testimony in a criminal proceeding upon a material issue of the case, but his testimony does not tend to disprove the position of the party who called him and elicited such testimony, evidence that the witness made such prior statement is not admissible, and such party may not use such prior statement for the purpose of refreshing the recollection of the witness in a manner that discloses the contents of the trier facts. That is precisely what the people did.
Okay,
That is precisely what they did.
why don't we hear from the people and we'll give you a few
And
minutes to respond.
I know I'm past my time, Judge.
You are, so,
want me to
but
sit
you will
down?
have a few minutes on rebuttal, okay?
Thank you, Judge. Yeah.
Thank you.
May it please the court, ADA Charles 1 for the respondent. Your Honor, at the prompt outcry hearing, trial counsel's objection was that the factual allegations of the 2013 outcry was different from those in the indictment. Trial counsel never objected that the note the victim gave to her counselor somehow refuted her 2013 outcry. So the issue is preserved for appellate review because the objections was on a different grounds.
So say that again, because that's what I read your brief, and that's what I thought you were arguing. But counsel seemed to say that he's arguing the same thing now that the trial counsel was arguing.
In the record, the trial counsel said the blood-touching outcry is not the same allegations that set forth in the indictment, which basically said that the defendant had raped her and committed incest to his daughter. And that's why he said the outcry should not come in because it is a totally different
From the
Indictment.
indictment.
So an inconsistency almost, or just very different.
Yes, Your Honor. And then following the...
It had nothing to do with the note.
That's correct, Your Honor. Following the victim's testimony, and I guess the note came in during the counselor's testimony, trial counsel never objected at that point, saying the note negates the victim's testimony that in 2013, she told her mother that defendant was inappropriately touching her behind. This claim was never raised at trial, so the trial court never had an opportunity to address it, so it is not properly before this court. And also the other issue regarding whether prosecutors' questioning of the victim's mother was proper or not was also not objected to. It is not preserved for appellate review. And
What about the way that trial counsel or the ADA tried to refresh her recollection? That's what counsel was just talking about before he sat down. Can you address that?
first, I'll point out that the information was already disclosed to the jury because the victim had already testified that she had told her mother in 2013 that her father the defendant was inappropriately touching her behind. And in this case, the prosecutor first asked the mother if she recalled the 2009 crash. She said no. And she said she did not recall it, and tried to just ask her, do you recall talking to the detective? She said no. So basically, where the victim was not being cooperative, I think the prosecutor was entitled to basically ask leading questions, which really only, and the prosecutor did not disclose any new information, as I noted. The information was already out there. The jury had already heard that the victim had made the 2009 cry. So in the
Wasn't there a question about whether or not there was a question about, did you speak to a DCS worker or something, which was not in the record because that report was not in the record? We don't even really know who called them and why who made that report. Wasn't that part of the problem? And did the judge then give some curative instructions relating to that?
Well, first of all, I mean, the prosecutor first asked about the detective, and the victim's mother said she does not recall. So at that point, the prosecutor tried to refresh her memory by asking about the caseworker, and it should be noted it was the caseworker. The prosecutor first asked, do you recall the caseworker's name? She said no, and she was asked, whether looking at the report, refresh your memory as to the caseworker's name. She said yes. So under the circumstances, I think it was appropriate for the prosecutor to then ask, we're looking at the caseworker's report, refresh your memory as to whether the victim had...
Then wouldn't that be a violation of CPL 60.35(3)?
Again, I think it's, under the circumstances, prosecutor was entitled to just ask leading questions, and
But the witness was never declared a hostile witness, so where would that permission come from to treat the people's own witness in that fashion and be able to employ leading questions?
Well, the prosecutor wasn't treating it as a hostile when they were just trying to, I guess, because it was involved information that was already disclosed, and she wasn't trying to impeach the witness. She was just trying to help basically refresh the witness's memory with information that was already disclosed at this point.
But so was there do you concede there was a violation of 60.35(3) then?
I don't believe there was a violation because she wasn't trying to impeach the witness. And the information was already disclosed. The jury already knew about it.
But when you say it was disclosed, what do you, how is, other than giving it, you can give it to her, right? And how do you mean it was disclosed?
Well, the substances of the question was basically, do you recall the victim telling you in 2013 that the defendant was touching her
And she
behind?
said, no, I don't recall that, right?
Right, and that was
And then, so how was this note disclosed?
the report wasn't, the disclosure, all the prosecutor really asked was, we're looking at the report, refresh your mind basically as to whether the victim made the outcry. And the victim already testified that she made the outcry, so that information was already, jury had heard about it. It wasn't new information that was being disclosed through the questioning.
Seems really tight. Okay.
If there are no further questions, people request an affirmance.
Thank you. Counsel, you have a few minutes for rebuttal.
Judge, as far as whether or not the issues were preserved for appellate review, I assert that they were, and at the prompt outcry hearing, and I'll leave that to the record. I don't want to argue with that any further. However, the two reports, the report from Detective Barringer and the report from the CPS worker, were never put into evidence, but they were used by the prosecution. I don't want to cast aspersions on the trial attorney saying that they used them illegally. However, whether it was by mistake or by design, they were used improperly under 6035 sub 3. They were used improperly during the...
Sir, I'm sorry to stop you, but your time is short here. Let's say we were to agree with you on that point. Does a reversal in a new trial necessarily follow from a violation of 60?
Absolutely, and here's why, Your Honor. Because then what followed was that they used those statements, those reports, in their closing arguments. And now one could say, and the people do argue, well, it is presumed that the jury followed the court's instructions on prompt outcry and the objections were sustained. Here's how we know the jury did not follow those instructions or listen to those sustained objections, because the first note out of the box from the jury was, we want to hear that CPS report. We want to see that. And the judge had to tell them, it's not in evidence. Then they said, we want to see the readback of Detective Barringer. And by the way, the people tried to introduce this report through Detective Barringer's testimony. Take a look at April 9th, pages 54 and 55.
CPS report.
This is the
also?
detective.
Well,
This
but
is the
he
report from the
testified anyway.
And the people tried to introduce his report through them, saying that there was a prompt outcry in Detective Barringer's report, and they couldn't get it in through Detective Barringer. Objection sustained. They couldn't get it in. And now they were trying to get it in through Ray Dallas, Urena. So first note out of the box, we want to see that CPS report from the jury, deliberating jury. We want to see that CPS report. We want to hear Detective Barringer's readback on his testimony. Second note, we want a readback of Ray Dallas. Global picture from 1,000 feet in the air. There was no confirmatory evidence of the complaining witness's allegations. None. The jury was looking for something to hang its hat on. There was no physiological evidence. They called, according to their doctor, there was no psychological evidence, no psychological ramifications at all. This girl was doing very well in school. Her life was going great. Their witness, something to confirm what the complaining witness has said, because there was nothing at all consistent in the trial. The only thing were those two reports that were never introduced into evidence.
Thank you. Thank you very much, both of you. We will take a look. Riseo versus City of New York.
Good afternoon, Your Honors. My name is Magda Riseo, and I am a petitioner appellant representing myself pro se in this matter. May I address the court? Thank you. I would like to ask this court to affirm the Supreme Court's 2023 decision that partially granted my petition to be exempted from the COVID-19 vaccine, and that reinstated me to my position with the NYPD. Your Honors, at this moment, I would like to address the 6 decisions that came from this court on similar matters, as well as correct the record for this court. Respondents rely on these 6 decisions that came from this court, pointing out that the circumstances in those cases were the same or very similar to the circumstances in my situation. And I would like to submit to the court that the circumstances were similar, but they were not the same. And they were not the same in the most critical aspect, which is the cooperative dialogue aspect. I asked explicitly for further, more interactive, and therefore more meaningful dialogue. I asked multiple times in different formats and at different points in time, all within the accommodation process and when I was still employed with the NYPD. In just my letter to the citywide panel, and I reviewed it yesterday, I counted 7 instances where I asked for some form of dialogue. I also explicitly asked in that letter for participation in the panel. None of the petitioner in the 6 cases decided by this very court did that. Your Honors, another significant difference, in my opinion, is that these 6 cases, in these 6 cases, the Supreme Court actually denied the petitions, and the Appellate Division upheld those denials. In my case, Honorable Erica Edwards, she partially granted my petition, and one of the reasons that she did that was, in fact, that in my application, I asked many times to engage with the decision makers at the agency level and at the panel's level via the cooperative dialogue, but that did not happen. Your Honors, another difference is that 4 petitioners in the 6 cases that came from this court, all of them, they were teachers, were directly engaged with the citywide panel with 4 questions. So they were given, in fact, an opportunity for further dialogue. Myself, as well as the remaining 2 petitioners, which was, I believe, Patrick Marsteller and Mr. Lee, we were never engaged by the panel. But again, the difference between me and these 6 petitioners is that I requested, and I actually underlined in my 2/15/22 letter to the panel, please invite me to the panel. I underlined it. And Your Honors, I understand that we had the process. We had the process at the agency level, and we had the process at the city-wide panel. This is not in question here. This was required by the law. The agency understood it. However, my objection is whether the process was interactive or robust enough to assess what it was meant to assess. And I believe that the 5 denial points that were given to me as an no explanation, were invalid criteria to deny me an exemption. Therefore, they could not have been rational, but in fact arbitrary and capricious. And I spent a lot of time in my submissions explaining why that is. And Your Honor, I just would like to take one more minute to correct the record for the court. Respondents in their final reply to this court on page number 1, they state I objected to just 2 of the 5 denials that the agency gave. That is completely false. The court is to review the entire record. I objected extensively to all 5 denials in my reply at the Supreme Court level, and I also extensively objected to 4 of them in my appeal brief and cross-appeal reply to this court, and that was insufficient documentation, generic response, lack of vaccine refusal, and the nexus between my religion and vaccine refusal. The remaining denial point, verifiable false information or misinformation, Your Honor, I'm still waiting to this day, and it's been a long time, for respondents to point to one thing that was verifiably false or misinformed in all of my submittals. Therefore, I would like to refer the court to all of my submissions rather than respondents' misinformation. And in the same final reply to this court on page 2, respondents state that they did not have to engage in a cooperative dialogue because of the raging pandemic, thousands of requests, and time constraint. And Your Honors, we don't suspend or modify our laws in extreme circumstances. Additionally, Director Malakowski from the NYPD, in his deposition, he stated that he and his team had everything they needed to review the applications, and if they needed more time, they could have asked for more people to review the applications, and they did, in fact, ask at one point, and they were given more staff at that point. I was surprised myself that in this type of an emergency and this type of threat from the unvaccinated, that there would be only a handful of people reviewing our applications when more resources were in fact available.
Okay, why don't we hear from the other side, and we'll give you a few
Thank you.
minutes to respond. Thank you very much.
May it please the court, Lauren O'Brien on behalf of the City of New York and the NYPD. Supreme Court decided this case without the benefit of this court's decisions in 6 separate cases addressing some of the exact same issues, starting with the cooperative dialogue issue first. In those 6 decisions, the court considered the exact same process that was at issue here and found that it satisfied the city human rights laws requirement that there be some written or oral dialogue between the requester and the agency. There's no, despite the fact that the petitioner may have requested additional dialogue or direct participation in the panel's review process, there's no requirement of direct participation under the city human rights law. And there's no rule that the employer has to engage in dialogue for a certain number of days or ultimately give the employee what she is demanding.
Or at least each situation is different from the others, right? Person to person might be required in one situation, but not in another.
To the extent, sure.
With this situation, it's one thing. Well, let's just talk about this. I don't want to say anything that broad that there's never any requirement, right? That
right.
There be
and I guess to your point that each situation is different here. Here, the agency felt that it had what it needed to make a reasonable decision and felt that it had a rational basis for its decision, and no further dialogue was required, despite requests for further dialogue. And the fact that there may have been thousands of these requests at the time, or that the city was facing this public health crisis is sort of relevant to whether it was reasonable for the agency to decline to engage in further dialogue past a certain point with any particular requester. And in our position is that this court's 6 recent cases are also determinative on the rational basis portion of this case as well. Some of the same reasons that were relied on in prior cases and affirmed by this court were raised here. And so unless this court has any further questions, I will respond to any questions on rebuttal.
Thank you. Okay, we'll give you a couple minutes to respond.
Your Honor, so I would just respond, maybe repeat myself a little bit with respect to the cooperative dialogue. Again, yes, there was pandemic. I never denied it. The situation was very serious. And the law says that the cooperative dialogue is required. I, again, asked for it multiple times. I had special needs, whatever the situation was, and the law says you can ask for it and you should be given. And especially, I would like to underline it, that I wanted it because I thought that the denial points, I don't want to call it reasoning, that was given to me that was not valid, that those points were invalid. And I explained extensively in all of my submissions what I thought that those denial points were invalid. And that's why I wanted to more cooperative dialogue, because everybody has a different religious life. For some people, like the Amish people, it's more sophisticated. Maybe for me, it's less sophisticated. I noticed I didn't even know when I was submitting my first original application that it would be appropriate for me to give to my employer an essay on my religious life, potential transformation, on conversion. I didn't know that. That's why I thought it was actually appropriate to have something succinct, to have something structured, and everything that I think of and why I thought I need an exemption is in that very first writing, whether respondents like it or not. So I think the two most important things from respondents was the cooperative dialogue. I think I addressed it, and the whether they had enough reason to deny me, and they might think that those 5 reasons were enough and that they were rational, but I didn't think so. I thought they were invalid, and I explained.
Okay, thank you. Thank you both.
Thank you so much for listening.
Next case for argument is Howard versus New York City Police Department.
Hello, judges.
Good afternoon.
Jose,
Okay.
I'd like to request in-camera inspection. This case is by Judge Kim. Duplicate of what I'm requesting, the 911 call from July 13, 2022. It being duplicated, according to Judge Kim, to the March 16th, 2022, also a 911 call. All right, so if you listen to the tapes, the call, the 911 from March 16th is Rosetta, myself, and Hakeem all on that tape, right? On the one I'm requesting for today, July 13, 2022, it's only Hakeem, all right? And the incident I'm talking about now, I walked in the store, all right, 4 months later. It's also 4 months later, July 13th. I walked in, Hakeem's there, I didn't say anything to anybody. I shopped, spent $39, went outside, about to walk home. I live 1 block away. Cop car from behind me. 4 cops. All right, so I stopped. I said, I know that's for me. Didn't do anything. Hakeem called the police because according to the cops, the cop eventually come over. First I said, go over there. Hakeem come out of the store, went over to the cops in the street. Like I said, over the outside. And talking to them, I started to walk over there. No, get over by the wall. Went over there. Eventually, he went inside. The one cop come over to me and says, don't worry, you're not in any trouble. Hakeem just thought you might do something. And then the cop tells me that Hakeem told them exactly that he thought I was going to do when he come in. And I didn't do anything. I just shopped. I left, blah, 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 blah. So anyway, I want that 911 call. I want to see what he said, right, for no reason at all, to get 2 cop cars and 4 cops there, right, for no reason. If you look at the paperwork for the case, you'll see even NYPD says no charges, didn't do anything, nothing cool. All right, anyway, Judge Kim is ruling it's a duplicate. All right, the tape itself wise, no. How can it be a duplicate? If you listen to it, if you determine that's a duplicate, you know what I mean? So anyway, you also have the request for the 911 call from March 16th. It was, I believe, April 7th. Put the request in, I have it here. The record of appeal on the case from 1566-21-2022. The record, the record on appeal for that case, right? It's I have it right here. It's page 24, and if you compare that to the request for July 13th, right? That's the record on appeal for that case, 100-416-2023. For this case, right? You can compare; it's completely different. All right. So with that being said, with Judge Kim, before she even got the case, right now she had the case March 16th. Before she even got the July 13th case, I have the like I'm pro se. I have the order to show cause. Judge Kim denies it. And so before she even got the case, she denies it. And her reasons were, which is right here, and this is page 5, 6, and 7, record on appeal for 100-416-2023. It's written right here in her handwriting, dated, right? Declined to sign, defendant NYPD is a non-suable entity. Judge Kim doesn't believe that the NYPD can be sued. It's right here, her handwriting, right? A plaintiff, blah, 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 pending under index 1566-21-22. Submitted and decision is pending currently. Let me see what it is. It says right here. And this petition is duplicative of the plaintiff's earlier decision. You can read it. She says, so before she even got the case, she has duplicate. So it needs to be looked into. You know what I mean? And I requested the 911, and I feel I should get it.
Okay.
Right? I was here September 17th for the March 16th, right? 5 judges. And I thought I was hopeful. I thought so, but NYPD here says that the ruling of the court is that the balance or something, the balance is that they don't want to release it because she would personal privacy or something, which that's completely
Okay,
wrong.
well, we're aware of that, so.
What's
thank you
that?
we're aware of that. We're going to hear
Okay,
from the
all right,
city's
well, you know what I
attorney.
mean?
We're going to hear from the city's attorney.
So-
Sir, you've used up your time. We're going to hear from the
I
city.
can't hear this, Judge.
You have used up your time. Please have a seat. We're going to hear from the city attorney, and then you'll have a few more minutes to speak, okay? Thank you.
15 minutes is up
You
already?
didn't get 15
Okay,
minutes.
all right.
It's a little more than we usually give. Thank you very much. We'll hear
Okay.
from the city attorney. You'll have a few minutes afterwards. Please sit down.
Good afternoon, Your Honors. May it please the court, my name is Elizabeth Friedman. I am appearing for the respondent in this matter. Your Honor, our position is there's no basis for an in-camera review of these documents.
Let me just remind me, the petitioner got the Sprint report, right?
The petitioner has gotten the Sprint report. It is redacted. It has 6 redactions. It is actually on pages 62 to 64 of the record. The Sprint report was released, which provides the details of the police response, the location, the nature of the police response, all of the
And that the
pertinent
call
information.
occurred, right.
And in addition to that, Your Honor, for a future appeal, the body-worn camera footage was in fact released. And the record here indicates that I know that there was a scenario that was not in the record that petitioner mentioned, but in the body-worn camera footage from this incident depicted Mr. Howard outside the Walgreens store, incessantly insisting that he must enter the store to return the products he had previously purchased. And the employee who called 911 explained to the officers that there was a prior incident on March 16, 2022, and he had returned to the store, and that the store employee
And that body camera footage was released.
Yes, it was, Your
So
Honor.
the only thing that wasn't released was the actual audio of the call.
The two audio calls, that's right, from
Okay.
March 16th and from July 13th, 2022.
Okay.
That was not released on the basis of privacy concerns and also safety concerns. This court, as you know, just last week affirmed the denial of upheld the exemptions on privacy grounds for the prior incident. The material requested here, the 911 audio recording and the unredacted Sprint report for the July 2022 incident is essentially the same, and that should be the order denying that FOIL request and upholding the exemptions should be affirmed on the same basis, as there is really no material difference between the two. One is from March and one is from July 16th, 2022, but the grounds for denying the FOIL request are the same in both. And therefore, since the court affirmed the prior order, the court should also affirm this order on the same grounds. Thank you, Your Honor.
Thank you. All right, Mr. Howard, you have 2 minutes.
Yeah, I was just like to say, see, if you view the body-worn camera, what she just said, completely wrong. The body-worn camera, the cops pull up, I'm already outside the store, right? And what happened was, after they told me, Hakeem called, blah, 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 the $39 worth of stuff I had, I said, hey, I want to return this. And then I went with discussion with the cops for 10 minutes. And me and the cops, we all went in and returned it. All you gotta do, view the body-worn cameras, 4 officers, listen to the 911 calls, that's all I ask, and then make a decision, all right? You know, it's untruth with this, the NYPD. You know, it's, you know why I'm here? You know why I didn't leave yet? Because I have a third case in November coming up. 4 of the body cams. And if I left today, right, especially waiting, I'm coming in for those body cams, and I'm going to have everything. I'm going to have everything I need to win that case. All right, so anyway, if you view the body cam and listen to the 911s, let me just say this. Judge Kim, duplicate, that's all she ruled. Duplicate on this case. Didn't rule on anything else. Duplicate. So with her, she's the duplicate right here, relitigating the whole freaking case. You know what I mean? Duplicate. That's all. That is not a duplicate, and I should get it.
Okay, well, thank you, Mr. Howard. Thank you, counsel. Have a nice afternoon. Thank you for coming in. The next case for argument is GIT versus Quinn.
Good afternoon. May it please the court, Eric Berry for the plaintiff appellant GIT Inc. As the court knows, this is a malpractice case alleging that Quinn Emanuel defended GIT on summary judgment motion in lieu of complaint, negligently defended that, resulting in a $100 million judgment against GIT. The key to the appeal and the key to the case, I believe, is in the third claim in our amended complaint. The third claim alleges that GIT did not invoke the defense of strict construction of guarantees, or strictissimi juris, to use the Latin. The reason that's important is because the guarantees, strictly construed, say exactly what GIT was guaranteeing. It says GIT is guaranteeing the loans, and it cross-references to the credit agreements for the definition of loans. The loans, as defined in the credit agreements, are not any debt of the subsidiaries, but a specific debt, loans made at the closing.
Well, look, I mean, in this particular case, I know you're talking about the third cause of action, and I'm sort of thinking more about the first cause of action, but the bottom line is, in reading all of these papers and in reading the affidavits submitted by the CFO and CEO, I might have gotten their titles wrong, but certainly high-up executives of your company, everybody seemed to understand that the way those documents were written, nobody ever expected two additional $50 million loans to be made. I mean, that seemed to be clear all the way. So what I mean, to ask us to interpret that differently, or to have asked Quinn Emanuel to have argued that differently before the federal judge, is hard to fathom.
The reason, first of all, there's no disagreement with factually, okay, we concede this. The reason it's important is because the fact that those loans were contractually promised but not made is necessary but not sufficient to showing the legal malpractice claim. The reason it's necessary is because you don't get to the parole evidence until you show that the written documents make no sense. So if you look at the parole evidence, what the parties had agreed.
But why, you just said we don't get to the parole evidence,
Until-
which I agree with you, unless there's some ambiguity or something in the
And
documents.
so I agree that with respect
So
to the
what's the ambiguity, or what doesn't make sense? I mean, they owed money on a prior arrangement.
right.
And so they were trying to negotiate something, so they negotiated this new agreement. What is ambiguous?
answers depending on what claim you're looking at. If you're looking at the claim that guarantees are not independently enforceable because of lack of
Consideration?
consideration, the answer is, if you look at the credit agreements, the cross-reference definition talks about loans made at the closing. Deemed loans, or whether they claim adjustments or credit extensions or refinancings, that's given a different term, credit extension. The credit agreements also say that loans are
Counsel, but you're saying, you're telling us that this law firm should have asserted a claim that it knew from your clients was factually false.
No, not at all.
Your client,
Not-
I
not-
read
no,
those
that's
two
not- we go to
affidavits,
great
so
lengths-
how could those?
We go to great lengths to make clear that's not what we're saying. We're saying that the guarantees
Your
specifically say
clients,
they
may
have
I
like-
interrupt you 1 second? and just
Let the
say-
judge talk.
Right. Your clients submitted declarations expressly stating their understanding of the plain terms of those documents. And now you are coming to us and saying that counsel should have asserted a different understanding of that document. That, to me, would be unethical.
No, well, first of all, Quinn Emanuel wrote those documents and we signed them. They're very legal, but this is
No,
a.
wait, let me go back a second.
This is a legal.
Why would that matter? If your clients didn't agree with what they signed and swore to.
Wait, let her finish, and then you can respond. That's the way it works here. Judge
Yeah,
Scarpula.
go ahead.
Okay, so the point with respect to the third claim is, you look at a guarantee strictly. The guarantee says not loans that are deemed into existence, loans that were made and have proceeds. Those loans were not made. That means the guarantees are out. What you are right, I believe, is that there is a logical claim that the credit agreements themselves are enforceable. Now, that raises a simple question. Was there consideration? The question, and that is a very simple.
I'm glad you brought that up, because that's really where I want to go, with respect. I just want to finish my sentence, but that's where I want to go, with respect to the lack of consideration, because let's figure this out. So there is an existing debt. From my reading, the obligations under the VPP documents, they were terminated. There was a new credit agreement to restructure the debt. That's not sufficient consideration?
Well, you have to look at what the documents say about the credit agreements. Section 2.1, you have to see what the documents say about the VPP document. Section 2.01 of the credit agreement states, UBS agrees to make a loan to the borrowers on the closing date in the principal amount equal to $50 million.
Let's go back, step by step. There is an existing debt, correct?
Yes.
All right. And then that obligation under the VPP documents, that obligation was terminated, yes?
Correct.
Okay. And because it was terminated, then there was a restructuring of that outstanding debt, and that's the credit agreement, correct?
And the
No. That's, to me, usually a yes or no. Which one is it? Is it yes or no?
There is a restructuring, but it's not consideration flowing in the direction of GIT. The part of the sentence that I wanted to read is that the $50 million loans would be made in exchange for and in consideration of the VPP termination. Now, the loans were undoubtedly consideration flowing in subsidiaries' directions. That means the exchange consideration, the VPP termination, goes in UBS's direction. And that's actually the reality. This court has specifically held in a decision called Corbett that
Just finish up, okay, Mr. Berry, because you're way over your time.
Okay. Okay. Do you want me to finish the sentence?
Just finish the sentence, yes.
Okay. This court specifically held in Corbett in 2017 that the agreement may have resolved what plaintiff was to receive for the work he had done in the past, does not, without some new executory promise on his part, create present consideration. That's our point. The new executory promise was made but never fulfilled. These are documents that do not, at either the credit agreement level or the guarantee level, and certainly the guarantee level, if strictly interpreted as they are required to be interpreted, do not indicate that there is the contractually promised consideration flowing to GIT. I agree that within the credit agreements, that's a very difficult claim, but if you look at the strict construction of the guarantees and the guarantees cross-reference to the definitions in the credit agreement, it becomes a very strong claim. It should have been raised.
Okay, thank you. You'll have a few minutes on rebuttal, counsel.
Good afternoon, Your Honors. May it please the court. I'm Kevin Reed from Quinn Emanuel on behalf of the respondent. Candidly, the court has articulated most of the points that I intended to make. I would just point, Your Honors.
I just want to say, I want to ask you, did anyone understand the documents at issue to state what the GIT now states that they did anyone ever raise with Quinn Emanuel that that's how the documents should be interpreted?
No, Your Honor. And in fact, as Justice Cohen pointed out in his ruling, he said, quote, "Nobody believed that this contract required the payment of additional funds. Obviously, the fact that no additional funds were provided and no objections were made is pretty clear evidence of that." So the suggestion that there was a reading of this contract that required UBS to disperse $100 million, UBS did not disperse $100 million, and over the course of the ensuing 3 years, GIT never objected to the fact that they never got $100 million.
And your client's GIT never said to Quinn Emanuel, wait a minute, where's my $100 million, right? That was never said. No one ever raised that as a possible defense.
No, of course not, Your Honor. As the affidavits that you
Right,
point out,
right.
what GIT came to Quinn Emanuel with was a claim that these loans were restructured, they replaced the VPP documents, but we believe we were fraudulently induced into signing the guarantee. And we defended that according to the theory that they articulated, and the judge rejected it.
Because of the valuation, the value, right.
They had a theory that they were misled into signing the guarantee because UBS suggested to them that in the event there was ever a question of solvency, that they would accept this PV10 valuation methodology. And then when it turned out there was a default, UBS didn't accept that methodology.
And that's what the Judge Stanton, I believe, in the federal court decided, and that went up to the Second Circuit, didn't it?
Correct.
And it was affirmed.
It was affirmed.
So that's, so what about the argument that he seems to be making now relating to the third cause of action and the guarantees? Anything you want to say specifically directed to that cause of action or that claim?
The third claim, Your Honors, is that it alleges that we had to construe the guarantee strictly, that what was guaranteed were loans. But then that brings you right back to what does the underlying loan agreement say? And his claim depends on construing the loan agreement to mean $100 million of new money.
Which we know that they've said that's not what it ever was supposed to mean.
Correct. Unless Your Honors have further questions, I'll see the rest of my time.
Okay. All right. Well, you have a couple minutes, Mr. Berry, so.
So, first of all, these are obviously lengthy and complex agreements, and these My clients are not attorneys, let alone litigation attorneys, let alone lender counsel, debtors counsel. They're regular people. They come into Quinn Emanuel.
I don't know if they're.
I know, GIT, the CFO and COO of GIT are regular.
People have, I'm not going to say anything about my clients. I think they are regular folks. But anyway, Quinn Emanuel doesn't say, wait a second, these loan agreements say they're supposed to be loans made at the closing. And if they had, the question would be not should these be made at the closing, but how does that impact the guarantee? Okay, and the impact on the guarantee is this. You go to the videotape, you go to the credit agreements, you read them literally. It says a loan is made at the closing, a credit agreement is deemed credit, and it says that the loan will have proceeds.
Except your clients never ever say that that's, in fact, they say under sworn declarations that is not what the credit agreement, I don't know how what you expect Quinn Emanuel to assert a claim that your clients swear is wrong.
I have been in this court where the question has been asked, what was the client thinking when he signed the affidavit? The client's thinking, and someone else on the panel said, well, what the client's really thinking is, why am I paying so much of this? And I hope this lawyer knows what he's talking about. That's the reality here.
No, but this law firm does, your clients are the ones.
What is the language?
Wait, Mr. Berry. Please let Judge Scarpula finish your question.
It's your client who, Quinn Emanuel did not draft these documents, did it?
Quinn Emanuel, of course, drafted these documents.
Okay, so when Quinn Emanuel drafted these documents with your clients, don't you think both parties would have said, we want this money to come in and structure the loan? That's what I'm saying. I don't
thought you were
understand.
talking about who's drafted the litigation documents.
No, I'm talking about the loan documents. Only your clients know what the loan documents mean, right?
O'Melveny.
Right.
did
So
not want money to come in.
Melvany's not here. Out of the
Right.
two, a litigation counsel and your client, only your client knows what everybody intended. So your client's the only one who could have told Quinn Emanuel, this is how the deal was structured, right?
Okay, that.
And then
goes
they
back-
swore
if
to
the-
it in declarations.
Okay, that means that if a client has a defense based on the law and based on the documents as written, but they're considered found money because the client wasn't negotiating for this defense, he can't raise it. That's not the reality here. Guarantees are of a special nature. They're strictly construed. The reality of this is we may well have been signing the guarantees in the event the $50 million came in. $50 million doesn't come in, we're not liable under the guarantees. If you look at the fourth point in our reply memorandum, every single definition in the credit agreements dovetails to make it clear that deemed credit is not a loan. The guarantees specifically say that only the loans is defined in the credit agreements, so you're either going to have to enforce it, not this court, but Judge Stanton, had this been raised, would have either had to say, I'm going to enforce the guarantees as written, or I'm going to send this case to a jury. And if it goes to the jury, then the legal malpractice claim has to go to the jury.
I gave you a lot of extra time since
Thank you.
your colleague didn't want to take all his time. Thank you both very much. Have a nice afternoon. The next case is Cartagena versus Hansford. Good afternoon.
May it please the court, Michael Zhu. I'm of counsel to Roland Henderson, attorneys of record for the defendant appellant, Dmitry Volosenko. The lower court here erred in denying Dr. Volosenko's motion to dismiss the complaint on the grounds that as a shareholder of a professional corporation who did not provide any professional services is not personally liable under both common law and the BCL. I'll focus on 1505A of the BCL because that expressly says that a shareholder is not personally liable unless you provide professional services. And here, Dr. Volosenko states in his affidavit that
Well, what about, even if we concede, because I actually think the doctor concedes that he was not involved at all with the direct treatment of the patient, of the plaintiff, so I think that's not really disputed. But what about the claim that your client effectively controlled all aspects of the clinic's administration, and could he be held liable in that respect?
that's on the PC. That's on the professional corporate. He wears two hats. He is the owner of the professional corporation, and he's a shareholder. But here, he's being sued as a shareholder in his individual capacity. I'm not up here to tell you that the supervision of the employees, I'm sorry, that no one is liable for failing to supervise the employees, that no one is liable for failing to have practices and procedures with respect to the administration of anesthetics. I'm not here to tell you that the PC is not responsible to oversee.
But it's not just the PC under the BCL, it's the individuals also.
Right, so
how can you prove that on a pre-answer motion to dismiss that he didn't supervise or control the treating physician?
Well, he states it in his affidavit.
Okay, but let's remember, pre-answer motion to dismiss.
Okay.
And we've many times said that an interested party's affidavit denying liability is not a sufficient ground under 3211A1, right?
Correct, I understand.
I mean, you might be right under a summary judgment, but this is a pre-answer motion to dismiss.
But he also relies on the medical records, which
for this one patient.
Which do not show.
Oh, but you think that that's enough? What if the doctor who did the dentistry testifies at his deposition? No, Volosenko every day supervised me, looked over my shoulder and every single thing, went through the medical records after the treatment and told me what I did right or wrong, right? How could we know at this early stage whether those treating records rule the day?
Okay, outside of what he states in his affidavit, there's nothing to support the assertion that he didn't treat the patient.
But ultimately then, it's simply putting the plaintiff in the position of having to accept your evidence and accept the truth of your evidence prior to discovery.
Yes, I understand. Thank you.
Thank you. We'll hear from your colleague, and you'll have 2 minutes for rebuttal. Good afternoon.
Good afternoon, Your Honor. May it please the Court, Christopher Della Carpini for the respondent, Ms. Cartagena. I'd like to first address the motion to dismiss as to the vicarious liability claims because the motion to dismiss did not address the vicarious liability claims. Ms. Cartagena clearly pleaded that Dr. Hansford was an employee of the practice and that he treated her son within the scope of his employment. That states a claim for vicarious liability under this court's decision in Brown, which we cited in our papers. Now, in the motion papers, as I said, Dr. Volosenko makes no mention of the claims of vicarious liability. His party affirmation, self-serving and unnotarized as it is, doesn't even deny that he employed Dr. Hansford. It doesn't mention Dr. Hansford. You can't earn dismissal on a claim by pretending it doesn't exist. Now,
well, you're not claiming that this doctor is malpracticed in terms of his own treatment, because he didn't treat.
Actually, the amended complaint does allege, as many of them do in these cases, that defendants, their agents and employees.
Yeah, are you okay? But you're not. He didn't treat this plaintiff. He didn't personally treat this plaintiff at the time that you are complaining that the malpractice occurred.
Your Honor, I don't know what happened when this boy was under treatment. I've seen the records. That's all I've seen. There has been no discovery.
Well, your client knows what happens. So your client knows whether or not that doctor treated his teeth, right?
Your Honor, I know what's in the record.
I'm asking you whether your client knows whether this doctor personally treated your clients. I'm not talking about vicarious.
I don't know that she knows that. I don't know that she was there when the boy was being treated. I don't know.
So you're saying you didn't investigate with your client who actually treated, who the actual treating physician was?
To defend against a motion to dismiss? No.
I'm not asking.
We are here on the sufficiency of the motion papers. And if they are insufficient, the motion should be denied regardless of what the opponent has put in opposition. And what the defendant has put in here to support its motion to dismiss is plainly insufficient. We have a statement from a self-serving affidavit from an interested party on matters exclusively within their knowledge and control. We can speculate about what Ms. Cartagena may know when she's deposed. God willing, we get to discovery. She will tell what she knows. On this record, we do not know what was going on in that room except what is in the chart, and what is in the chart does not exculpate Dr. Volotsenko. What he relies on in the chart is the list of providers in the column in the chart. Some of those providers are listed only by initials. He doesn't identify those people. One of those initials ends in a V. But let's assume Dr. Volotsenko is nowhere to be found in the chart. As you said, Your Honor, that doesn't mean that he wasn't involved in the treatment.
Did you claim before the motion court that this doctor actually treated the plaintiff?
Claim before the motion court? No.
Did you deny? So he puts in papers, he puts in an affidavit and the records that say, I did not personally treat this person. Did you put in anything to raise an issue of fact to dispute that evidence? The
No, we did not.
Okay, that's all I want to make sure. Okay.
And if I may add on that point, we didn't have to, because what we have here is an affidavit from a self-interested...
And medical records.
We do have medical records.
Okay.
We don't have anything from Dr. Hansford. We don't have any... I think I made my point on that. I will also say, as to the office chart, even if Dr. Volotsenko is nowhere in there, there is a separate claim for his liability for the negligent management and supervision of the practice, particularly the administration of anesthesia. If he's nowhere in the chart, that doesn't mean he was not negligent in those responsibilities, which are also alleged. So, as we said, there are facts to be discovered in this case, and there's every reason for this court to affirm the denial of the motion below and let us get on with discovery. Thank you.
Thank you.
Just one very brief point.
Sure.
As to the claims of the supervision and control over Dr. Hansford, who is a named defendant, the issue is not, or should not be, whether Dr. Volotsenko is personally liable for the failure of the PC to supervise and control that independent contractor.
But the BCL has not just the PC, it's the individual partners and shareholders in this circumstance. If they are, you didn't put in the employment agreement. How do we know how the two of them interact with each other? All you put in was the Secretary of State's PC stating, I formed a PC.
He's a sole shareholder.
Right.
Dr. Volotsenko is a sole shareholder.
Right. So that's all you put in, but you didn't put in what the relationship with him and the treating dentist is.
But my point is, if he doesn't provide professional services under the BCL, the shareholder has no personal liability.
Isn't that premature now for us to make that determination? We haven't done any discovery. It's just a 30-11 motion to dismiss. So we don't really have too much of the evidence before us. We just have the records and the complaint, and that's it. So that's what we're basing it on. It's not summary judgment. We'll get there another day.
I understand the court's position.
Okay.
Thank you.
Thank you both. Okay, and next we have Zabal versus the City of New York. Sorry if I pronounced that wrong.
May it please the court. My name is Nicholas Calabria with the law firm Vomny, Demers, McManus, and I represent the appellant Carlo Lizza and Sons Paving, Inc. We're hearing this appeal on a denial of summary judgment motion. Carla Liza did work on Woodlock Avenue in the Bronx, New York. In 2012, they did some milling work for the city of New York pursuant to a contract. The work was done in 2012, was inspected by inspectors in the city of New York, and then the road was paved over. 4 years later, the plaintiff was riding his bicycle in the area, in an area that he said he rode on 2-3 times a week, and in fact rode on it about a week and a half before, and there was no holes or anything in the road. This day, on May 26, 2016, he's riding down the street at 10 o'clock at night with no lights on, and suddenly his bike flips, and he sees this giant hole in the street. Plaintiff brought the action based upon that testimony, some photographs, which have to be looked at page 390 and 395 to see the size of this hole, and it's a...
Did you present evidence to the motion court that, in fact, the area that you had done the milling work where plaintiff alleged she fell was actually inspected by city engineers and found to be reasonably safe at the end of the job?
Well,
I mean, I know your client is no longer in business, so it's hard, maybe a little bit harder for you to get records or witnesses, but...
Well, fortunately, Carla Liz has been involved in a lot of personal injury cases in the city of New York, so we were able to put together...
Unfortunately.
Well, the reason I say fortunately is some of these cases they got out of on this, almost the exact same evidence. Yes, we did submit the milling reports from the city of New York, which showed when they did it. We had a testimony from one of the inspectors on another case, how they would inspect it and then let the city pave over the area where we had done the milling work. We had submitted an affidavit from a Carla Liza manager, again from another case, again attesting this is the way it went. 4 years later, there's this hole in the road, and the plaintiff himself said it looks like there was recent construction there, and he had ridden over that area about a week and a half before, and there was no hole there. So to just blame the milling work, which is preparatory to the paving, without any other proof by the plaintiff that we caused this hole. There's no expert testimony saying that improper milling will all of a sudden erupt and make this giant 4 by 5 foot hole. And I would address the court to the Jones versus Consolidated Edison of New York and McDaniel, City of New York, 2 cases that I cited in my brief, where under the exact same scenario, this court dismissed defendants from the case for the paving work that they had done in preparatory to the paving, because the plaintiff never submitted any evidence to show that the milling work could have caused this defect. So the contract, there was no duty to the plaintiff, and there was no negligence, and therefore the motion for summary judgment should have been granted. Thank you.
Okay, thank you. We'll hear from Picone, the co-defendant.
Good afternoon, Your Honors. Gretchen Becht from Newman Myers Cranes Harris for defendant Picone. Picone met its prima facie burden, and plaintiff failed to raise a triable issue of fact. The motion court erred in finding that the screenshot of a website listing permits was sufficient to raise a triable issue of fact. There's case law, multiple cases from the First Department saying that permits alone are not sufficient to raise an issue of fact as to whether work was performed at the accident location. So a screenshot of a website listing permits definitely should not be sufficient to raise a triable issue of fact.
Before we get to their evidence, what did you put in to establish your prima facie case?
Well, the motion court did not dispute that we met our burden. We put in evidence of the Mr. Germano's deposition testimony stating that Picone performed work 113 feet away from the accident intersection, which was shown in a time and material reports. You could see in the time and material reports there was a diagram showing that the work performed by Picone occurred 113 feet away from the accident intersection. So we're arguing that that is sufficient to meet Picconi's burden proof. The court did not find otherwise. It simply found that plaintiff raised a triable issue of fact with the screenshots of a website listing various permits. Plaintiff had FOIL documents going back to 2011 and didn't come forward with any permit that was listed in that screenshot. So it's just simply insufficient to raise a triable issue of fact, Your Honors.
And counsel, if I may, Germano, I believe he was shown some exhibits, right? And there was the testimony that those defects appeared to be, I guess, let's say, incomplete work, and that wasn't Picconi's work because they, previously
Right. I mean, it seems the case law seems to be showing that work was performed away from the accident intersection is sufficient, but in addition, we also showed that the work that Picconi did perform was not defective because he said, like you said, he said that the pictures that were shown to him, he said that's not our work because we completed the job, and we also had they had a inspector come in who certified that the work was done properly, and Picconi plaintiff did not submit any evidence to refute that.
Thank you. You'll have time on rebuttal. Counsel for the plaintiff.
Good afternoon, Your Honors. I'm Mark Gazzoni from the Office of David Up Law, PC, representing the plaintiff appellant, Kevin Zabal. As to Carl Lee's contentions, they had no testimonial support whatsoever, but they moved for summary judgment anyway. No support for any exhibits, nothing. Why? Because they're not in business anymore. There's plenty of companies that aren't in business anymore. 99.9% of them, I would guess, aren't, that have ever been. But that doesn't prevent their principals or other people with knowledge from coming forth with testimony in support of a motion for summary judgment. But in addition to that, there are photographs, and one in particular that I know is before Your Honors and is part of the record, show milling. The testimony regarding that milling that I used in my opposition came from the Picconi defendant. And I asked him questions about
the mill. I thought the documents that I read showed that the milling was done 4 years before plaintiff's accident. And if I understand correctly, milling is done, kind of scrapes up the old, whatever it is that it covers the roadway. And then they come back and they pave the top of it and it's all covered over. So what could the milling 4 years before that was completed sufficiently have to do with the fall that your client had in that area that he showed in the pictures that caused him to fall?
It wasn't completed sufficiently because the photographs show it's irregular. It
At
looks
the
like
milling, someone actually said that it showed the milling was as opposed to the paving over the milling?
it's facially apparent when you take a look at the photographs that it's irregular. It looks like a topographical map of a mountain range. In addition to that, it was supposed to have been kept broom clean. No testimony as to that.
What's supposed to be kept broom clean? The streets in New York City?
No, the milling, before you pave over it. Because if you don't, it doesn't stick.
Okay.
And in addition to that, if it's irregular, it might have issues with sticking as well. But nonetheless, the milling, the area of the milling was exposed, and it was an irregular surface, and as a result, my client fell. But we're presuming that they met their burden. They didn't. They could not have prevailed on a motion for summary judgment without any testimony of somebody with direct knowledge. All the cases that you see, case after case after case after case, direct knowledge testimony.
What do you say about some of the affidavits that, I guess you're talking about Liza right now,
yes.
That Liza put in from some of their former employees from other cases? Do those not have any evidentiary value in this case?
Absolutely not. No evidentiary value whatsoever, because every case is specific, every area is different. We can't make a presumption that they behave the same way. It's entirely speculative that they would do the same thing under the same circumstances or similar circumstances here that they did there. Negligence is predicated on a departure. So looking at other testimony regarding something else has no bearing and certainly can't make a prima facie here. I would, as my time is running short, I would like to switch defendants. Pacone was very similar. They proceeded with upon the testimony of a witness who never visited Whitlock Avenue. He had no idea. He
They put in evidence that they didn't do any work at the accident site, that the one thing that they had was 113 feet away, and they didn't do any work at the accident site. So let's assume that they met their prima facie case, which the trial court said that they did. What did you put in to raise a triable issue of fact?
I put in a showing that there were 30 other permits that were
What was
unaddressed.
what was the showing?
That is a showing that there is
What did the showing consist of, I guess is what I'm asking you.
The showing would be that there were 30 permits.
What is the
Whitlock
showing?
Avenue.
What is the showing? What do you mean by the showing? What did it consist of?
It consisted of 30 records of the city of New York.
Records?
Wasn't it a
format,
screenshot? Wasn't it a screenshot?
It's a screenshot and it appears right in the records. It is a compilation made by the city of New York, put in a format.
But do we know if those records were even, if those permits were actually issued, if they were just filed for? Do we know anything more about them? Or was that screenshot in and of itself sufficient to carry the day?
Well, I don't believe there was an objection by counsel at the time as to their admissibility, and there was no objection as to their veracity, stating, hey, these records don't exist. There hasn't been any since. But I would just like to add one thing. They did not make their prima facie because he stated not affirmatively that there was not other construction. He said none that he was aware of. And he based that upon a very cursory review of some records. Now, just because they did construction at one location doesn't preclude the fact that they could have performed it at another. It's such as I put in my papers, just because an attorney is licensed to practice in New York doesn't preclude the possibility that they could practice in New Jersey. Hence here, just because they performed work at one place doesn't mean that they didn't perform it at another. In evidence, those screenshots are evidence because it makes it more likely the proposition that there was other work performed.
Are you saying that screenshots that are unauthenticated by anyone are competent evidence?
I authenticated them. I certified them.
You
It's a
can't say that.
2106. 2106 permits me to do that as though I were a clerk, and I did. And I linked them in addition. But most importantly, who objected? Objected to their application, yes. Objected to their admissibility, I don't recall anything about that.
Okay, thank you. We'll just give each of the defendants if they...
Thank you, Your Honors.
Thank you very much, counsel. Anything further, Counselor?
Yes, Your Honor, I just want to address the evidence. Again, we're out of business. We could not produce a live witness, but we did produce evidence. We did produce affidavits. If they were from another case, it's still an affidavit.
Well, did it deal with the same location?
It dealt with the same contracts that were the subject of this case and the process by which the work was done. They would mill, it would be inspected by an outside inspector, and then the city of New York would inspect it, and then they would pave over it. Now, the photograph, again, it shows this giant hole, and counsel, I guess, is saying that his interpretation of this photograph is that it's grooved. Yeah, that's exactly what the milling is. You can't put the paving down on a flat surface. You have to scrape it up so that there's something for the asphalt to adhere to. So by saying the photograph shows milling, well, that's because the hole is that big. I don't know why the hole is that big. There's no testimony where this hole came from. All we know is that a week and a half before, the plaintiff said he rode his bicycle down that same path and it wasn't there. And he said, but it might have been construction. And he was talking about construction from a week and a half to the date of the accident. Thank you, Your Honor.
Okay, thank you. Counselor, you got 2 minutes.
Mr. Germano had sufficient knowledge. He was a project manager, and he said that he actually reviewed the permits and also video and photographs produced during site inspections. He reviewed that on a monthly
Okay, but
basis.
how do you deal with counsel's assertion that you didn't object to the screenshot?
Right, well, that was the colleague of mine who did the motion, and even though he didn't object to the admissibility of it, he did clearly argue that a screenshot is obviously insufficient to raise an issue of fact, since your court has decided on numerous occasions that permits alone are insufficient. So, and even if he produced an actual permit, that itself is insufficient. You have to show that actual work was performed. So I think we sufficiently addressed the issue.
Okay, thank you. Thank you all.
Hey, counsel. Nice papers, nice job. It was good. I didn't want to do that. No, you know why? Because afterward I realized, I mean, at the, okay. No,
I wasn't going to raise it unless you
let me tell you what the issue was with it. I would have been able to